So how can you effectively ensure health and safety compliance in a hybrid workplace? It's a big question. So employers will need to be mindful of their health and safety obligations to both in-office and home-based staff. For in-office staff, the main focus will be on how to implement a safe return to the workplace. And for home-based staff, employers are likely to face new challenges that they've already been facing, including ensuring that working patterns are not detrimental to health or risk employees suffering burnout. They'll also need to ensure that employees have safe equipment and a suitable workspace. So there are a number of employer duties in this area. Every employer has a duty to take reasonable care of the health and safety of their employees, and this duty arises both under common law and under the Health and Safety at Work Act. It's also an implied term of employment contracts, and employers will need to provide a reasonably suitable working environment for the performance of duties. They must also provide and monitor working environment which is reasonably suitable for the performance of employees' contractual duties, and employers must conduct a suitable and sufficient risk assessment of all of the work activities carried out by their employees, including home workers, in order to identify hazards and assess the degree of risk. They must also abide by the implied duty of trust and confidence, and they're required to do everything reasonably practicable to manage health and safety risks. And if challenged, the onus is on them to demonstrate that they did so. So while the pandemic continues, we now know that common features of the pre-pandemic office pose obvious risks, such as packed lifts, shared workspaces, communal areas, and hot desking. So the question is, how do you bring employees back safely, bearing in mind all of the duties outlined? So the best way to demonstrate compliance with health and safety obligations is usually to follow government and industry-led guidance wherever possible. Current government and health and safety executive guidance focuses on the responsibility of employers to take steps to ensure that the workplace is COVID secure. Employers should take measures that include undertaking a risk assessment and sharing the results with their workforce. And the HSC has produced a risk assessment template to assist employers undertaking these assessments. Following the assessment, introduce any necessary health and safety policies and provide training on them to ensure compliance. If anyone becomes unwell with COVID symptoms, and we're now more familiar with those, they should be sent home and arranged to have a test. So policies that you can introduce might include social distancing, flexible working and staggered shifts, and that can include allowing for different start and finish times in order to avoid busy trains and tubes. Commuting to and from the office can be seen as an extension of the workplace. Also ensure frequent cleaning, adequate ventilation, providing hand hygiene facilities, and where using hot desks can't be avoided, cleaning workstations and shared equipment between occupants. Employers should also monitor the effectiveness of the measures they put in place and keep their assessment under regular review. Employers should also ensure that they consult with employees on plans to return and on any health and safety measures to be put in place, with consideration being given to those individuals with higher risk. So we suggest keeping lines of communication open in order to address any concerns quickly and avoid unnecessary issues escalating as well as potential claims. So it's not yet known how long protection from vaccination will last, sadly, or whether it will be effective against the new variants. And there's some obviously frightening information that's coming out at the moment about those. And it's likely that employers will need to manage employees' concerns about returning and being in the workplace on an ongoing basis for the foreseeable future. So while employees have further protections and rights that I'll come to, it's also worth remembering some of their obligations that come into play. So every employee has the duty to comply with the reasonable and lawful instructions of their employer. They must comply with the terms of their employment contract, and they must take care for the health and safety of anyone who might be affected by their acts or omissions while at work, as well as to cooperate with their employer so far as is necessary in order to ensure compliance with statutory duties or requirements relating to health and safety. There are a number of claims that can arise in this area that employees and some workers can bring as well. So where an employee or a worker raises concerns around health and safety, Claims could arise such as unfair constructive dismissal for employees, detriment and dismissal claims which are covered by the health and safety provisions of the Employment Rights Act, and from whistleblowing detriment and dismissal claims covered under whistleblowing legislation. Workers are also protected from detrimental treatment. Under sections 44 and 100 of the Employment Rights Act, an employee may be protected from suffering detrimental treatment or being dismissed where automatic unfair dismissal applies, as well as uncapped damages, where there are circumstances of danger which they reasonably believed was serious and imminent, as a result of which they took appropriate steps to protect themselves and others. Now, whether or not risk of infection could constitute serious and imminent danger, and whether or not refusal to go into work or leave the office could amount to appropriate steps to protect oneself or others, is a question which we need to be considered on a case-by-case basis. It is worth noting that the government has already described the pandemic as a serious and imminent threat to public health and safety. So the concept of danger has been interpreted broadly in case law, and it could include the risk of contracting COVID from an infected colleague, patient, or client. So the question for the tribunal will be whether the employee reasonably believed that attending work could put them in danger. This highlights the importance of effective communication with staff in terms of the measures taken to minimise the risk in returning to the office. Much would also depend on the current state of the pandemic, and the serious and imminent danger test may be less likely to be met where the level of cases has dropped significantly. So it's also worth touching on whistleblower protection, because even if it's not reasonable to assert that there was a serious and imminent danger, it is possible that the individual could be covered by whistleblower protection. And for a whistleblowing disclosure of information to be protected, the whistleblower must have a reasonable belief that the information tends to show one of the relevant failures in the Act, such as danger to health and safety or a breach of legal obligation. They must also have a reasonable belief that the disclosure is in the public interest, although this is a low threshold test, and most health and safety concerns are likely to qualify. However, such disclosures may not necessarily justify refusal to attend work, and the basis of any disciplinary action would need to be carefully analysed. We would suggest getting legal advice at the outset, as these things need to be handled quite carefully and delicately. So employees who are concerned about their health and safety may choose to raise issues in the first place with their line manager, and if the issue is still not resolved, raise a formal grievance or go through the employer's formal whistleblowing channels if they have these. So how to mitigate the risk of claims? There are a number of ways in which employers can, as set out on the slides, and just touching on a few of those. So implementing the suggested measures, such as carrying out a risk assessment and implementing or updating policies, training staff on health and safety duties and how to protect themselves and others, and ensure to apply disciplinary processes and sanctions where necessary. Update or implement a whistleblowing policy and train managers to deal with such issues and make staff aware of how to raise a complaint and how to access the correct channels of communication. Also, consider reasonable adjustments for vulnerable groups and those with disabilities, and seeking medical advice where required. So what health and safety issues could arise with people working from home? Quite a few. And employers could face various issues in this regard. So a number of things such as managing staff dealing with increased stress levels, possible burnout from the lack of division between home and office, ensuring that staff have safe and appropriate equipment, and being mindful of discrimination risks given continuing disparities in who takes more responsibility for childcare or caring responsibilities, and the likelihood that more women than men will work from home and do. So issues could arise if, for example, those in the office are favoured for work or are receiving better performance assessments and consequently pay rises or bonuses because they appear more present and managers have more visibility over their work. So how to mitigate the risks? Some examples: ensure home workers and in-office workers have equal access to all information, both in terms of internal resources and information about developments and changes within the business. Have regular catch-ups with home workers and ensure that virtual social activities are continued. And consider hosting all team meetings virtually, via Teams for instance, so that everyone is involved in the same way, or consider if there might be a day when all members of the team can be present in the office together for meetings, although in this new time that might be more logistically challenging. Offer to carry out individual workstation assessments, and this can be done remotely now, and remind staff to take regular rest breaks as well as encouraging annual leave. Employers will also need to address further practical issues, such as tailoring standard employment contract clauses to encompass home working and taking appropriate measures to protect confidential information and personal data.